Live in 5, 4, 3, 2, 1.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, gentlemen, and welcome to the Court of Appeals. We appreciate you agreeing to participate in oral argument via Zoom. It is not the way that we would prefer to do it, but it's the way that is the safest and best way to be doing it now. I want to remind everyone, all of you are experienced appellate practitioners. You know the rules, you know the procedures, and we will be following those rules and procedures just as if we were in the courtroom today. Mr. Hebner has shared with me previously that he has spoken with each of you, and you have agreements as to how much time each one of you will be taking for your argument. And of course, the appellant will get its rebuttal time if requested. Mr. Hebner, anything we need to take up before we get started?
No, Your Honor.
All right, before we do that, though, let me be sure and introduce your panel for today. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. And since we have a full screen here, let's go ahead and proceed, and you may call the case, Mr. Hebner.
Elvis Presley Enterprises, Inc. et al. Versus City of Memphis et al.
We will hear from the appellant.
Thank you, Your Honor. May it please the court, Clarence Wilbin for the appellant. We're here today, Your Honors, on this matter that was the result of what we believe to be reversible error by Chancellor Cal from the Shelby County Chancery Court. This case arises from what we refer to as the Graceland TIF and a TDZ that was granted to Graceland by the state of Tennessee, Shelby County, the city of Memphis, and the Industrial Development Board, which is commonly referred to as EDGE here. So Graceland received the TIF, under which they received tax incentives that allowed them to help finance the redevelopment of the Graceland campus, which included the Four Diamond Hotel, known as the Guest House at Graceland, a sound stage, and other amenities and facilities for the tourists that come to Memphis to tour Graceland and otherwise tour the city of Memphis as a whole. So that at the initial TDZ and TIF allowed Graceland to receive 50% of the tax incentives to go back into the campus. Graceland, due to the success of the program, Graceland subsequently went back to EDGE, the county. When I say the county, I mean Shelby County, and the city of Memphis to get that increased from 50% to 65%. So with the additional 15% being earmarked for a 6,200 seat arena, some additional wing on the hotel, and some other expansion projects on the campus. But the county and the EDGE, they conditioned Graceland's receipt of the additional incentives on Graceland either reaching an agreement with the appellees that they didn't have any objection to Graceland using the additional funds, or obtaining a order from the Chancery Court, the local Chancery Court here in Shelby County, establishing that the using the 15% in no way offended what we refer to as the arena use agreement, which is the operating agreement between the city of Memphis, Shelby County, and the Memphis Grizzlies that was agreed to when the Memphis Grizzlies relocated from Vancouver to Memphis to start their basketball operations here. So, as would be expected, because the county resolution and the EDGE resolution that established expanded the existing TDZ and TIF to the additional 15% specifically instructed Graceland to go to Chancery Court and obtain this ruling that the additional 15% in building a 6,200 seat arena did not offend the Shelby County, the arena use agreement. Graceland did just that. It filed a lawsuit against the appellees in which it simply asked for that interpretation of the arena use agreement. Now, to be clear, Graceland in no way, or EPE, I use that interchangeably, in no way was requesting the Chancery Court to enforce the arena use agreement, to alter the arena use agreement, or otherwise take any action whatsoever related to the relationship between the Memphis Grizzlies, the Shelby County, or the city of Memphis. The EPE, again, was solely seeking to have the court interpret the what we believe to be an ambiguous provision of the arena use agreement to determine whether or not they could use the 15% that had been granted or awarded to EPE by the city and the county. Now, I won't attempt to go into a history lesson regarding the charter of Shelby County, other than to say that we know that Shelby County operates through the county commission. So for all purposes, the county commission is Shelby County, and that's who it acts to. And Shelby County, again, is a party to the arena use agreement, as well as to the resolution that established the additional fund for the use of the construction of the 6,200 seat arena. So it's against that backdrop that EPE approached Chancellor Cowell. Chancellor Cowell dismissed EPE's lawsuit on the basis that EPE lacked standing to seek an interpretation of the lawsuit. We're here because we believe that that was reversible error, because as we know, standing is a man-made document. There are 3 elements to standing, and EPE has satisfied all 3 of those elements. The first element being whether or not EPE has a distinct and palpable injury. And EPE does, in fact, has a distinct and palpable injury, because there's one resolution that governs this, and that resolution flows and applies solely to EPE under the Graceland, TIF, and TDZ. The Graceland, TIF, and TDZ is unique to Graceland and EPE. No other taxpayer in this community.
Just a minute, Mr. Wildman. Why doesn't this apply to everyone? Anyone who would want to do something? Why is your client distinct and different than every other citizen or person who would want to come to Shelby County and try to obtain the same concessions that your client is requesting?
Well, Your Honor, if you look specifically at what we refer to as the carve out in the arena use agreement, in that you have to be positioned to be a tax incentive. The carve out requires a tax incentive program for a specific purpose. And here you have Graceland, the TIF, and the TDZ. This is only an issue because you're using tax incentives. So there are no other citizens.
That, but why is it not? Why would not the same application apply to anyone who wanted to request this type of arrangement from the county?
Well, Your Honor, I don't know that it would or wouldn't apply, but here it's, again, you have to have been approved for a standing is at the time that we're looking at it. And here currently, the only person that it applies to is Graceland because of the Graceland, TIF, and TDZ. So no other person or entity could have Graceland's TIF or TDZ. No one else other than Graceland could use those funds. So you could never have any other entity or individual step into Graceland's shoes or be similarly situated to Graceland. So any other taxpayer that came up and said, I want to use these funds, well, they couldn't because they wouldn't have this specific TDZ and TIF. Again, this whole thing buttresses on the TDZ and the TIF. That's it. So that's why it's unique to Graceland. There's no one else similarly situated. It could be similarly situated. That's what makes it distinct and palpable. It's like the Calfee case that we cited, those particular homeowners. Well, no other homeowner, outside of that particular group could say, well, I own a home in the state of Tennessee, I'm similarly situated. Well, no, you're not similarly situated. Just the mere fact that you are a homeowner, you have to own that piece of property. And here, this rises and falls solely on Graceland's TIF and TDZ. And that's what makes it distinct and palpable. So if you look at any other individual or entity, again, Your Honor, there's no one else that could make this argument or even be harmed or, in the way that EPE is harmed. And that's what makes it unique to them at the time that we were looking when we filed the complaint. And as we sit here today, that's why it's distinct and unique and palpable to EPE. And then we know that there's a causal connection between EPE's harm, which is the inability to use the additional 15% because it's being blocked by the failure to obtain the interpretation of the arena use agreement. And again, this is not asking the court to enforce or to take any action to, under the arena use agreement. This is solely relates to how does this agreement affect the Graceland TIF? And to your point again, Your Honor, when you're asking the question of how does the arena use agreement impact the Graceland TIF and TDZ? So no one else could have that specific question because they could never have this same Graceland TIF for TDZ. And so that's where we have our distinct and palpable injury, and then you have your causal relationship between the two, because failure to obtain the court not allowing EPE to obtain the interpretation is blocking and prohibiting EPE from taking that next step under the resolution that would allow them to receive those additional 15% funds. And then finally, on the redress, well, obviously, this an interpretation by the court that says this, the arena use agreement does not prohibit EPE from using the additional funds to construct the arena, clearly would redress the problems because you check the box and satisfy a contingency that's within the resolution itself. And once that contingency is struck or is met or satisfied, then Graceland can proceed with the next phase of the development of the Graceland campus.
All right.
Thank you.
Thank you, sir. We will hear from the appellees. I assume y'all have agreed with who's doing what and how much time each one of you are taking.
Yes, good morning, Your Honors. My name is John Lakey and I represent the city, and we have divided up our time. The city will begin with 6 minutes of that time.
All right.
The case before this court obviously is on remand from the Supreme Court, and there's only one issue, and that's standing, as Mr. Wilman has indicated. I will address why appellants do not possess the requisite constitutional standing necessary to obtain the interpretation of the arena use agreement, including in particular why their reliance on CalFee is misplaced. Mr. Jones is going to, who is counsel for Shelby County, will explain why the county's contingent resolution did not authorize appellants to stand in the county's shoes, and nor could it. And Mr. Wade will go last and also address standing, in particular why EP is not a third-party beneficiary. The arena use agreement is a contract. It was entered into between the city of Memphis, the county of Shelby, and Memphis Basketball LLC to secure the relocation of the NBA franchise to Grizzlies from Vancouver to Memphis, and it governs the operation of that arena in Memphis called the FedEx Forum. Real quickly, with regard to a couple of the factual points made by Mr. Wilman, I want to correct a couple of things. He's indicated several times that if the court gives it the interpretation of the contract he wants, EP can just proceed. That is absolutely not the case. The city council of Memphis has not voted on the increased TIF or the ability to use the TIF for an arena. There is nothing that if this court rules in its favor and Chancellor Kyle interprets the contract he wants in the way he wants, the EP is not free to do anything because city council has not voted on the EDGE resolution. Moreover, he keeps making this point that EP is not trying to seek to enforce the contract. They're not trying to assert any rights, but yes, they are. They're asking this court and they're asking Chancellor Kyle, and he denied to do so, to create a binding interpretation on the actual parties to the contract. And there's no dispute. EPE is not a party to the agreement, and neither are they an intended third-party beneficiary of that contract, as Mr. Wade will go into in greater detail. But even though they're strangers to the contract, what they're asking Tennessee courts to do is bind the actual parties to the agreement with an interpretation of it. And if in order to do so, what they've tried to do is try to use a declaratory judgment act as a way to get that. And they advance two arguments in their briefs why they can do that and why they have standing and each fail. First, they argue they don't have to be a party to the contract. They don't have to be a third-party beneficiary of the contract because they have some legally protected interest in public funding to build a competing arena. Number one, factually, that's incorrect. They don't have any ability right now, regardless of this contract, to go forward and build an arena with public funds. Alternatively, appellants assert they are an intended third-party beneficiary of the agreement, and that's not correct. So let's turn to that first argument, because they rely really heavily, both in their supplemental brief to this court, in their arguments to the Tennessee Supreme Court in briefs, and in their first briefing to the court on the Calfee case. And in fact, what plaintiffs state in their supplemental brief to this court at page 3 is that the Calfee court, and I want to quote this, made clear that one does not have to be a party to a contract or a third-party beneficiary to have standing to challenge the legal validity of the agreement. End quote. That statement is flatly wrong. Calfee does not stand for that proposition, not even a single bit. Consider what Calfee does not involve. Calfee does not involve a contract. Instead, it involved a challenge to a land use permit that had been issued by the Tennessee Department of Transportation. Calfee does not involve an action brought under the Declaratory Judgment Act. It involved a case brought under the Administrative Procedures Act. Calfee did not involve the interpretation of a contract. Instead, it involved a permit, and it didn't involve the interpretation of that permit. Instead, it focused on whether TDOT had exceeded its authority in issuing the permit. Thus, for purposes of standing, the court in Calfee looked at the legally protectable interest, which was the right of free use of the land of the plaintiffs and how it was impacted by the permit. EPE is not challenging the legality of the arena use agreement or whether the parties had the power to enter into that agreement. And moreover, Calfee didn't involve legal injuries arising from a contract or the interpretation of contract. The plaintiff's claims were tort-based claims on trespass to land and tortious interference with riparian rights. It's well-established jurisprudence that in contract matters, to have a legally protectable interest, you must either be a party or a third-party beneficiary to the contract. Appellants don't cite a single case that conflicts with that. And when you look at the plaintiff's complaint, you see it's a DJ action. DJ action is a substantive cause of action. It's procedural. So what underlies it? They're seeking an interpretation of a contract between parties that aren't seeking that interpretation. I would commend the court to our brief. As I see, I'm running out of time. Kruger versus State of Tennessee involved an actually declaratory judgment act seeking a contract. The Court of Appeals upheld the dismissal of standing and noted that the plaintiff wasn't a party or a third-party beneficiary. And I appreciate the court's time. Thank you.
Thank you. Mr. Jones, are you next up?
I am, Your Honor. May it please the court. I will be speaking for 3 minutes on behalf of Shelby County. Just to address
Mr. Jones, I know who you are, but you need to introduce yourselves because we're being recorded.
Yes, Your Honor. I'm John Jones. I am the Chief Litigation Attorney for Shelby County, Tennessee, and I'm arguing for Shelby County in this appeal.
All right, sir.
It's EPE's theory, Your Honor, that the county, via the county resolution, specifically instructed, authorized, and ordered EPE to attempt to attain this declaratory relief that it seeks. And relatedly, EPE posits that the county made EPE the county's agent for the purpose of obtaining this declaratory judgment it seeks. EPE, if the court please, is wrong for several reasons. First, standing is a judicial doctrine. The county's legislative body does not, in fact, cannot confer standing on EPE. Instead, it's the role of the courts to determine whether a particular litigant is entitled to have a court decide the merits of a dispute or of particular issues. And that is from the Tennessee Supreme Court in the Darnell case, 195 Southwest 3rd, 612 at page 619.
Mr. Jones, let me pose a question to you.
Yes, sir.
Does the appellant in this case obtain any additional rights or have any inherent rights here to seek the interpretation of the contract simply because it's a Shelby County resident, taxpayer?
It does not, Your Honor, and as Mr. Lakey has discussed and as Mr. Wade will discuss, this is a government contract. The EPE is certainly not a party and is not a third-party beneficiary to the contract. It sits no differently from any other citizen of Shelby County. It does not have any special rights or any palpable injury arising out of this contract.
It makes no difference that, in other words, I'm trying to ascertain if the fact that this is a government contract and we're dealing with a government entity here, are there any particular or peculiar rules that might grant the appellant more relief?
I say I'm out of time. Let me attempt to answer Your Honor's question. The answer is because it's a government contract, it is in fact more difficult under the case law for EPE to demonstrate any sort of right to a declaration under the contract.
All right. Thank you, sir. Appreciate you responding, and we will hear from Mr. Wade.
Thank you, Your Honors.
Thank you.
Thank you, Your Honor. David Wade, appearing for Memphis basketball or the Grizzlies. The court's question is absolutely on point. Under both the Citizens for Safety and Clean Air Act case and Coburn versus City of Dyersburg, it specifically stated that a contract entered into by a government entity requires a showing that the contract was intended by the parties to confer a direct obligation to identifiable third-party entities. Every contract into which a governmental entity enters is made for the benefit of all its citizens. Only when such a contract manifests a specific intent to grant individual citizens enforceable rights thereunder may a citizen claim such rights as a third-party beneficiary. I'm going to address the issue of third-party beneficiary, not to construe the contract, which is not appropriate in a standing issue, but because Elvis Presley Enterprises makes an ancillary claim, it is a third-party beneficiary under the contract. We got to look at two things, obligations and consent. Elvis Presley Enterprises is not a party to the arena use agreement. It's an arena use agreement. It's between the city and the county and the Grizzlies. The Grizzlies came because the city and the county wanted them. The city and county was obligated to build an arena. The Grizzlies agreed to lease the arena, to pay rent, and also to pick up all the costs and expenses of operations, including losses. That was the deal. Memphis needed the Grizzlies, and it agreed to build this arena for sports, entertainment, concerts, and primarily basketball. At the end of the day, there's no obligation in this agreement to EPE. What happens with respect to the agreement, the operation was that because the Grizzlies were picking up the costs and expenses, the Grizzlies required a non-participation clause. It's at pages 91 to 93 of the record. The non-participation clause is exactly what it says. The city and the county agreed that without the prior written consent, and this is the second important word, consent, of Memphis basketball, it would not provide economic or tax benefits or incentives or materially participate in the financing of a competing facility. Why was this important? The Grizzlies have all the operating costs and expenses. If the city finances a competing facility to compete with its own arena, the Grizzlies are faced with revenue being poured off into this other facility. So in order to prevent that, the Grizzlies only asked for the right to not consent to such a situation. In other words, The carve out that Mr. Wilbon's talking about comes after the word consent in the non-participation agreement. It says that the city and county can continue to have a planning or permitting department, and it can establish programs for tax benefits. That's all it says. Then the next sentence says that if the Grizzlies consent, then other provisions of the contract will apply. There's nothing that gives Memphis or gives EPE the right to do away with the Grizzlies consent agreement. Now, there are qualifications later on in the non-participation clause. The Grizzlies can't withhold consent that will work against the obligations of the city to its citizens, nor can it withhold consent for discriminatory purposes. Other than that, the Grizzlies have the contractual right to withhold consent. Now, Elvis Presley Enterprises can apply for an application, which it's done. It can try to get tax benefits, which it's done. But the Grizzlies hold the right granted to it by the citizens, by Shelby County and the city to object and not consent to that. And if the Grizzlies decide not to consent, that's the end of the question. That's a contractual right conferred on the Grizzlies. As I said, there's no obligation that runs to Elvis Presley Enterprises. And any citizen, as Judge Stafford pointed out, could come in and say, well, I want funding to have a competing facility. They can apply for that. But if the Grizzlies don't consent under the contract, they can't get public funding to compete with the public facility, the arena, to draw away revenues that the Grizzlies have the right to in order to cover costs and expenses that they're obligated under the contract to cover. You know, with all
so if I understand your argument correctly, Mr. Wade, and correct me if I'm wrong, that there is the opportunity for someone to have standing to challenge this, but it has to be in very specific enumerated instances. Is that correct?
No, sir. There is no basis for a non-party to come in as a third-party beneficiary.
For instance, withholding consent for a discriminatory purpose. One of the two things I think you mentioned earlier on in your argument, a discriminatory purpose where the Grizzlies could not withhold consent for that purpose, or when it would work against the rights of the citizens. And that's a bad paraphrase of what you said.
Yeah, it is a pretty bad paraphrase, but I understand the intent of the court. No, Your Honor, there is no right to challenge what has been granted to the Grizzlies. Now,
how would you
the parties to the contract can interpret its meaning.
Okay.
The parties to the contract have the right to interpret the meaning, but there is no third-party beneficiary that has the right to come in and challenge the enforcement or the intention or the meaning of the agreement.
So in no instance would anybody be able to say, I'm asking for a declaratory judgment because, for instance, the Grizzlies or withholding or Memphis basketball is withholding consent to allow this, and it is a blatantly discriminatory purpose.
Nobody but the parties. The city of Memphis could certainly complain about it, because if the contract with the city of Memphis was being violated, a party could certainly complain about it. Yes, Your Honor.
But it would have to go through the city of Memphis or through the county, I'm assuming is what.
Yes, there is no case in the United States that we found that allows an entity, not a party or not a third-party beneficiary to a contract, to have it interpreted or to try to enforce it.
Okay, thank you.
Mr. Wade, I just have one final question. I want to make it clear. There's nothing to restrict EPA from using its own money to build this arena. It's only the public money. Is that correct?
Yes, sir. And yes, Your Honor. And that was in my outline to say that the EPE can go build this arena anytime it wants to. It just simply can't draw on public funds, which would compete for a competing facility. Now, when they did their contract back in several years ago, it was no competing facility. They got approval. Now they want to use 65% of the funds over the tax base to fund a competing facility. They don't have the right to do that if Memphis Basketball refuses to consent.
All right, thank you.
Yes, sir.
All right, we will hear from the appellant in rebuttal.
Thank you, Your Honor. Your Honor, if I can answer address the last question first. With respect to EPE's ability to build the arena with its own money, Mr. Wade's answer was only partially correct. EPE could build the arena with its own money someplace else besides the Graceland campus. Because of the Graceland TIF and the TDZ, you can't use the money. The city and the county have maintained that property is tainted, because they say that because the property itself has the TIF and TDZ, that it's not just you get the dollars, that it's covered by the entire property itself. So that's only a partially correct answer. So the actual answer to your question is yes. If you buy land somewhere outside of the Graceland campus, you can build the arena, but you can't build it on the Graceland campus because the tax incentives flow to the actual campus. They don't flow to a particular building like the hotel. It's the campus that they cover, and they don't flow to EPE's direct pocket. They flow to the campus and the things on the campus. So you can't do that either. It'd have to be off the campus. So the correct answer is no, you cannot do that. And if I could also address another question that kind of stood out when Your Honor was asking Mr. Wade about no one ever having any standing whatsoever. Therein lies the rub here, is that you cannot contract away and say, no matter what, we can discriminate, we can do whatever we want to any citizen, and there are no circumstances in which the citizen could ever go and protect their rights. So I think that's a major issue that's here. But also with respect to the intent,
if the city or county, if it was determined that there was some discriminatory action, the city or county as a party to the contract could enforce it.
But Your Honor, you'd be asking the city you'd be asking the party to the contract to enforce the discrimination against themselves. So the only parties to the contract that would be discriminating would be the city, the county, and the Memphis Grizzlies. Those would be the three that are discriminating. So would the city actually come and file suit against itself? It wouldn't do that.
Well, I'm assuming there's some other discriminatory purpose or discriminatory action that we're talking about here. And as I understand it, if it's determined, if a citizen were to bring that to the city's attention, then the city could enforce it. Or in other words, if a citizen could bring it to either the city or the county because they're parties to the contract, and then they could go into court and enforce it, not the citizen themselves. Is that correct?
Oh, I don't know the answer to that, because I don't know why the city, if the citizen brings to the city and say you're discriminating, why would the city file suit against itself instead of just stop discriminating? They're the party that would be discriminating. They're the ones under the contract. So you would be asking them to stop doing what they're doing. So I don't think they would file suit against themselves or their own behavior.
All right. Well, we're kind of circuitous here, but I'll move on.
And with respect to the third-party beneficiary, that's a question of, that and the agency issue. Those are intent questions that are not appropriate on a motion to dismiss. We have to remember that this suit, we're here on a motion to dismiss. That's what Chancellor Cal granted, a motion to dismiss. If you look at that, all EPE was that was at the pleading stage. So EPE put forth sufficient evidence in the allegations of the complaint that was to be accepted as true, that the county, and if you look at the allegations where the county says we're instructing, authorizing, and telling EPE to go to court and get this interpretation. And it's throughout EPE's complaint, it clearly says the county is in the county commission, which is the county for all purposes. If you look at the charter, and that's in the complaint as well, that's how the city acts. I mean, the county acts. The county commission said, go get this interpretation.
Let me ask you a question, Mr. Wilman. Is that the only, I guess, avenue by which your client becomes the third party beneficiary? Is the instruction that the county gave your client? Is that what you're relying on?
No, sir. Your Honor. The other avenue is what's clearly is the arena use agreement itself, where it specifically says in the non-participation provision, where it says that this agreement is not intended to exclude arenas like this, or it says it refers to transactions and activities normally and routinely engaged in by the city and the county, the general purpose of which is to encourage private development in the course of establishing tax incentive programs. The Graceland TIF and TDZ are private tax incentive programs that the city, the county, and EDGE encouraged under this, and they, so that's the other point for the standing is it's a specific carve out that says this arena use agreement cannot prohibit these kinds of activities. They can't do it in connection with establishing a tax incentive program. And that goes back to the earlier question, Your Honor, of why nobody else is in this situation. The county and the city, the appellees, encouraged EPE to do this development pursuant to a tax incentive program as a transaction and activity normally and routinely engaged in by the city with a private developer. And so you bring that full circle, that tells you exactly why EPE has standing to get this interpretation, because you have a provision in here that says EPE, you can do this, but the city, the county, and the Grizzlies are saying, no, you can't, and you don't have a right to ever go and challenge whether that's correct, despite the county being a party and saying, yes, you do. And in fact, we want you to go and do it.
Okay, thank you.
Thank you.
All right, gentlemen, we appreciate your argument. We will take this matter under advisement and attempt to render an opinion on it at the earliest possible time. Again, we appreciate you participating by Zoom. Is there anything we need before we recess court to call the next case? All right, you may recess court then.
This honorable court is now in recess until 10 a.m.
Thank you, Your Honors.